this morning, the U.S. Supreme Court struck down an Arizona voter registration law. In a 7-2 decision, the High Court ruled the 2004 law requiring voters to show proof of citizenship when they register is unconstitutional. The ruling could impact other states with similar voting laws, like Alabama, Kansas, and Georgia. And joining us now from the Supreme Court is NBC News Justice correspondent Pete Williams. Pete, thanks for being here.
You bet.
All right, so walk us through this ruling today.
Well, what the Supreme Court said is what Arizona tried to do is preempted by federal law. That is to say, federal law is supreme on this question of how federal elections are conducted. It said that this Arizona law runs contrary to a 2-decade-old law called a motor voter law. It basically says that you can register to vote when you get your driver's license, but it also says you can register to vote by mail. And if you do so, you fill out a federal form, and there's a little box on it that you check that says, I swear I'm a U.S. citizen, and then you sign it at the bottom. Now, Arizona went further in this law. It passed in 2004 by voter initiative Prop 200. It required people to show documentary proof that they were citizens. And what immigrant groups said is this is an attempt. Arizona defended this law, by the way, by saying it would help to prevent voter fraud. But groups representing immigrants said it was just an additional hurdle that they had to get over because they wouldn't be able to do so as easily by mail. They'd have to bring documentary proof. If they didn't have a passport, they'd have to bring their naturalization forms. Strangely enough, there's another federal law that says you can't copy your naturalization form, so they'd have to bring it in person. For all those reasons, the Supreme Court said Arizona can't do this. It's an additional burden that the federal law does not require. Now, what the 7-2 majority said today, an opinion written by Justice Antonin Scalia, is that if Arizona really feels strongly about this, it can ask the federal government to change the form and require people to bring this proof. And if it doesn't win, it could go to court and try again. But for now, Arizona can't do this. The other states that were following Arizona's lead can't. And about a dozen or so states that were waiting for this decision to see if they too could do it, now they can't do it either.
Right, and this is an interesting split because typically people think of Antonin Scalia and Clarence Thomas being on the same side. But an interesting split. Tell us about the two members of the dissent here, the two people on dissent.
It was just Justice Thomas and Justice Alito. They think that the federal government, that the Supreme Court's majority got it wrong. This had to do with a reading of the law. What the law says is that states must accept this federal form to be used in federal elections. Arizona said, well, we accept it, but we just need more, just like the TSA accepts your driver's license to board, or the airlines accept your ticket to board a plane, but you also have to show some form of ID. And it was Arizona was saying, we're just doing the same. We're accepting the form, but we're asking for more. And today the Supreme Court said, no, that's not what accept means in the context of this law. So it was actually an interpretation of federal law rather than a constitutional decision. But you're right, it was a somewhat unusual breakdown, not the usual 5-4 pattern. But there'll be time enough to see that.
There'll be time to see that. Okay, I want to bring the panel back in. It is interesting because Arizona produced evidence, Josh, that between 2005 and 2007, they could only show 19 non-citizens who'd registered to vote out of 2.7 million registered voters. But interestingly enough, Arizona actually rejected about 31,000 applications to register to vote, 87% of which were Hispanic. So at the end of the day, this was essentially a law that overburdened potentially Hispanic voters.
Right. I mean, I think that there isn't very much voter fraud, and the reason is that it's a really inefficient way to try to change policy outcomes. Trying to get a lot of people to spend their time going and casting fraudulent votes one by one is just not an effective way to affect change, even if you were willing to break the law. So I think these fights do really tend to be about trying to control voter turnout. Republicans see it as advantageous to make it relatively more difficult to register and to vote, and that's really what the fights are mainly about. But when you talk with conservative Republicans, they are convinced that voter fraud is a real problem. It's not that it's a pretext for them, and they don't want to admit that it's a pretext.
Right.
They really
think
this.
That's how Barack Obama got elected. You know, I want to bring Rick in there and ask you about the Supreme Court sort of timetable here, because now we're going to have a whole bunch of decisions coming in basically in the final week of the calendar. Is the Supreme Court sort of putting off its homework here? Are they kind of procrastinating on their work, or is it just that these things are so complicated?
Well, it's interesting that this ruling is not based on a very high-minded kind of constitutional principle. It's based on the idea that federal law is superior to state law. It doesn't go into right to vote and what makes this country great and all that. It seems they're deciding this on the ground that will be the narrowest and that will enable to put together the largest majority, because this endless stream of 5-4 decisions is undermining the court itself. I mean, I would be interested to know how much of a hand Chief Justice Roberts had in this, because he has shown, as he did with the Obamacare decision, a lot of concern for the reputation of the court and the legitimacy of the court. And a 7-2 decision is always more legitimate than a 5-4 decision.
Pete, I want to bring you back in and ask you specifically on that question that Rick brings up, because there does seem to be a desire among John Roberts, and we can't read his mind, to have decisions that do firm up the reputation of the court. So with a 7-2 decision in the bag, what are the tea leaves that you're reading there as far as these other big decisions on DOMA, on Prop 8 in California, decisions on the Voting Rights Act? Are these things probably going to break down more along the traditional lines of 5-4?
Well, I think that was a foregone conclusion on those cases, and the decision today doesn't tell us anything about those. This was always a statutory interpretation case, always a question of the reading of the federal law. What does it mean when it says the states must accept this form? So it was always a very narrow legal issue in this case to start with. We're going to have decisions again on Thursday. We know next Monday is a decision day. Undoubtedly, they'll add another day next week. So we've got 3, maybe 4 decision days left. We have 14 cases remaining. The biggies among them are the same-sex marriage cases, Prop 8 in California, the federal DOMA, the Defensive Marriage Act, the Voting Rights Act that you mentioned, and then the challenge to affirmative action in college admissions.
All right.